My topic is risk distribution in Charterparties in respect of GHG measures, that's greenhouse gas measures. And what I wish to discuss is how parties could react to GHG measures of different kinds. And I'll try to say something about how governments could or should design GHG measures. And in this session, this will be supplemented by Pia's discussion of different non-governmental initiatives, and Henrik's discussion of pollution liability and pollution measures compared for GHG and other kinds of marine pollution. So I think this is going to be quite an interesting session. And at least I haven't been to a session where we try to combine all these aspects in this way. Feel free to interrupt me at any time, and hopefully we will still be able to save some time in the end for a joint discussion of all presentations. So then we try. The GHG measures, they're all about incentives. Governments wish to give incentives to try to get commercial parties to act as they wish to. It is possible, of course, to have control and command type rules, like a speed limit on ships. But in most countries, governments wish to give softer incentives. And one of the reasons why they do that is to get people to act in a commercially sensible way. And if they use command and control measures, it tends to be that some gain get lost unnecessary. And we try to design all these measures so that the parties should act with the least societal loss. That's very important. And governments also need to be very aware of disincentives. And I'll show you some of them. So, and in particular, if you introduce incentives, that may have quite other effects than you think it has. And we have to be very careful, and we have to design measures so that we do not have disincentives for GHG emissions reductions. It's been a little bit hard to find a way to organize a discussion of this. So I have made this overview of my presentation. Unfortunately, I have more slides, but these are the main slides. This is so that I will revert to this so you know where I am, like a map. And as you see, the first slide is about government-initiated costs. And as example, I will use the emission trading system of the EU, where you pay a fee for the amount of GHG you emit. And then it's I will say something about party-initiated savings, because you can call this natural incentives. So parties wish to save fuels, for example, by slow steaming. I think it's to get the full picture, we need also to know something about this. And I will say, how will this be distributed in the outset in different kinds of charter parties? And then I will turn to government obligations. What kind of obligations do governments have? And then my last two groups of slides will be one about incentives, how to make them more effective. And the other one is about reducing these incentives. So as it's easy to get lost in this, I will revert to this overview, and I hope I can take along on this little journey. The first system is the government-initiated measures. And I think you all know about the emission trading system. Or some of you. I'll try to keep my feet still. Yeah. And the system is that a vessel arriving at a European port will have to buy a permit for its emission. At this stage, it's just for a half of the emissions in many cases, where if they trade to non-European Union ports. And the idea is that perhaps the port in the other end also wish to have a similar system. But if the IMO doesn't come up with a system within a time limit, the EU has clearly stated, then we will charge 100%. To me, this is not problematic in international law, even if they had asked for emission trading permits for 100% already at this stage. When a ship is in the port, it's under the jurisdiction of the state. And although there have been some discussions about this in international courts, I think it's a fairly clear-cut majority view that this applies also if the tax, as in this case, affects behavior at the high seas. The case I'm referring to is the North Star case, where the majority of the ITLOS actually actually suggested that there was no port state jurisdiction for taxes if it affect or even could have a chilling effect on the behavior at the high seas. So what's the initial cost distribution here? Who should pay this levy? And it's defined as the ship owner. It's not necessarily the ship owner as we would define the ship owner in maritime law, but it's not the cargo, for example. And that's the initial cost distribution. And politically, that is often the discussion. How should the initial cost distribution be? But that's not really very interesting from an analytical point of view. We need to see how will these costs be redistributed. And the first kind of redistribution is via the market. So what happens if I, as a ship owner, have to pay a levy? Well, then, of course, I will say, I cannot sign this contract unless I get some more freight. And I think we safely can assume that in all cases where one of the contractual parties in a free market is subject to a levy, that will influence the price. That's a Coase theorem. And I think we have to sort of consider this when we discuss the effect of the levy. Is it a levy on the ship owner? No, it's a levy on the two commercial parties, the charterer and the ship owner. And the effect is decided by the effect of the price. And there's much to say for the notion that this effect will be the same either you start in the end of the ship owner and puts the levy on him, or in the other end and puts the levy on the charterer, who then will say, well, I have these extra expenses, so I cannot pay as much freight as I used to. So we cannot always know how this will work, but the government cannot place a cost between two contracting parties where they, for some reason, think it should be placed. That is very important. The exception is, of course, if there's not a free market. Well, in shipping, it will very often be a free market. But temporary, of course, a binding contract will restrict that. So if you have a 10 or even 20 years charter party and you have fixed freight rates and one of the parties is levied some kind of ETS costs, then that will be rather expensive for him. And then you have to turn to the contracts. Are the clauses there to redistribute the costs? And in a time charter party, this will perhaps be considered to be costs associated with ports. If you go to EU port, you have to pay this. And that will, in many time charters, be on the charter. In English law, one would look, is there a basis for in the contract for redistributing the costs? And in Scandinavian law, we have a functional approach. So we will say, is this something that has to do with the ship or the employment of the ship? And very clearly, these will be costs that are to be borne by the time charter. And then there is this interesting clause in the ETS directive, and it's called Article 3 GC. And why is it called GC? That's because they have amended this old directive from 2003 with a number of new articles. And in order to make it perhaps more edible, they have used letters rather than numbers to denounce the new clauses. And here it says that member states shall take the necessary measures to ensure that when the ultimate responsibility for the purchase of the fuel or the operation of the ship or both is assumed by an entity other than the shipping company pursuant to a contractual arrangement. That's a time charter party they're talking about, isn't it? The shipping company is entitled to reimbursement from that entity for the costs arising from the surrender of allowances. So even if there is no basis in the charter party to claim these costs back, one can do that on the basis of this clause in the EU directive. Quite surprising. This means that it doesn't matter whether you are bound by a contract, because this will override the contract. And it will also mean that typically the time charter will have to pay the whole levy. And it will not be redistributed as if there were no contract yet. And the cost theorem would apply, and the levy will be taken into account when negotiating the contract. There is a problem here. We have this small island, which is not a member of the EU anymore. And they have this strange attitude. They say, we don't want to listen to what they legislate in Brussels. Surprise. So in a charter party under EU law, governed by English courts, no, in the charter party under English law, governed by English courts, you cannot invoke this clause in a charter party dispute. But it says in the EU provision that member states shall take the necessary measures to ensure, etc. And that would mean, as far as I can see, that the member states should and could open for a reimbursement action in the EU. That's very surprising. But this is not a charter party conflict, although it affects the parties of the charter party. It is a public law measure. And as we shall see, it's important from a public law point of view who pays the levy. We now go to slow steaming, and here the incentive is not the levy of the ETS, but it's the fuel costs. One wishes to reduce fuel costs. Of course, the government can influence them, and I've always recommended that governments, rather than using this elaborate ETS system, just put a levy on fuels. That will be much easier to keep an overview of. And of course, if this speed is reduced, there will be a benefit from that. And in time charters, the benefit will be for the time charter. They pay the cost and they decide the speed of the vessel. It works quite well, doesn't it? In voyage charters, what will happen then? Well, the ship owner may be allowed to reduce speed, and that will be for his benefit. And the poor guy is the cargo owner. He will get his cargo later on. And the only comfort he will get is that it's because of the environment. At least so the ship owner says. Are there any mechanisms for benefit redistribution here? No. It really isn't. Now we have seen the initial situation. And I should perhaps say something about the effect of this. And I have an example here of demurrage before I elaborate this even more. Let's say I'm a voyage charterer, and then I ask the ship owner to go to that and that port, and the ship owner may be inclined to go slow, and that will have the disadvantage for me that I will get a place in the queue in that port a little later. So therefore, I perhaps have some provisions of the speed of the vessel. For the ship owner, he will think, well, if I get to that port very soon, the waiting time will perhaps be longer, because the waiting time in this port is not governed by the time of arrival, but for example, by the ETA of the vessel, or when they announce that they are supposed to come. So then you have this. You know these charts, don't you? We have this this situation here where the ship owner has to decide what to do. And even if there are some incentives to go slow, for example, the emission trading levies, then he could earn more by actually speeding up and getting to the port earlier, so that he will earn more demurrage. And you have to see this in conjunction. And you see this line here. This is the cost of the bunker fuel oil. And that will increase with the speed. And the more you increase the speed, the more the cost will increase. So you speed on, and the cost per hour gets to this level here. And if as long as the cost per hour is less than the demurrage, it will be good profits for the ship owner to speed up. Only if the demurrage is so low that you reach the ceiling, it will not pay to speed up. So there's a connection here between these mechanisms in the Charter Party and what the people do and how the incentives work. So remember the different slides. It's so that on this Zoom I didn't get back to the overview as I had intended to, but now we have seen a little bit on the initial distribution. We'll say a little about government obligations. Well, first of all, we have the Paris Agreement. Governments have in very round terms agreed to try to reduce emissions. But as you know, shipping is out of the accounts for the Paris Agreement, and that's the only binding commitment of it, that the state parties should report. That's left to the IMO. But then there is a very interesting advisory opinion of the International Tribunal for the Law of the Sea in Hamburg from May this year. And the question is, what kind of obligations do governments have under UNCLOS to reduce emissions? And in the same way as the European Court of Human Rights, and in the same way as the UN Commission for Human Rights, the ITLOS states very clearly that there is a commitment. The government has to do something. The European Court of Human Rights is very concrete and say, well, you have to do this and this and this. Although in procedural and broad terms, they do not want to make policies. But ITLOS is not that concrete, and for some reason they use pages to discuss whether this is an obligation of result or of attempt or commitment. And it's only they should try the best they can. But it's very clear that there is a concrete obligation. And I think we could use that even when discussing charter parties, because governments should intervene and make sure that incentives work in the right way. And if the government has this duty, I can see no reason why not also the courts should have a similar duty. Of course, courts are not bound directly in many countries by international agreements. But international courts have been very proactive here. And I see no reason why, for example, Norwegian courts should not consider this obligation under international law. The governments cannot really say something about courts being active in this way, because they are already committed to doing this. How could we make the incentives more effective? How could the governments use this obligation and powers? Well, first of all, I think there is a problem that we don't really know who will carry the costs. It would be much easier if you could see whether the charter of the carrier could will actually pay. And one way to make this a little clearer, although not all the way clear, would be to put the levy on the vessel and not trying to specify who should pay in the first place. Then it will be very concrete that the parties have to agree who should pay it. And that will also help because one will target the decision maker. It's not so that the person who can decide, for example, slow steaming, will not have the power to decide slow steaming. The person who should pay the levy will not be able to reduce speed of the vessel. In time charters, this works quite well. In voyage charters, as I said, this doesn't work well, because if there is a possibility to reduce speed, this is on the voyage voyage carrier, and the benefit will only end up with the carrier, while the cargo will suffer. The cargo will then probably argue quite heavily that you cannot reduce speed. I get nothing from it. So the government initiative should then be to reduce these incentives. And one could do this, for example, by first of all, making it clear that due dispatch of the vessel doesn't mean that you cannot go slow steaming. We tried to do that in the draft implementation of the Rotterdam rules in Norway. We said that this clause should be understood so that slow steaming would be allowed. One could do something about the demurrage clauses, saying that we should not allow a system of incentives that will not encourage slow steaming. We could do a lot in connection with ports, and they are often government controlled. So that there's not an incentive to go fast in order to get a place in the queue in the port. But I think rather than going into the contracts here, one should look into benefit sharing, so that if one of the parties actually earn money on reducing speed or other ways to save emissions, then that benefit should be shared. That way, the likelihood is that the parties would agree on that. That would be a very effective government intervention and make the incentives much more effective. It may happen that a contract needs to be renegotiated in such cases. And I like the notion of environmental force majeure. You can simply say that, well, here is a new situation, either because of taxes or because of the environmental crisis or other things, so that the contracts need to be renegotiated. Binding contracts are valuable, but the environment is a lot more valuable. And finally, I'll just point that it's very likely that in such a case, a ship owner would perhaps say that, well, the reason why the ship was a little bit slow was because of the environment, but the really reason was something else. So we have an evidence problem here. And I do not think shipping arbitration in general is set up to really evaluate claims that what was done as an environmental measure. So we will have to strengthen the possibilities there to get evidence. So this is my advice to governments. I would very much like to hear your views, whether this is horrific or whether it's good or whether you think it will work. Will the incentives be more efficient in this way? Thank you.